I want to export Touch and Go to joint states. What are the specific IPR issues needed to be addressed before undertaking exports?
I'm glad that you are concerned. Amongst the first things you should do is to undertake a freedom to operate FTO analysis in the export market.
Freedom to operate? What's that?
Well, freedom to operate is conducted to determine whether marketing a product or a process can be done without infringing intellectual property rights of others in the territory being considered for market. FTO analysis is anywhere required before introducing any product in a market.
Freedom to operate analysis, carried out to determine if your product or process infringes someone else's IPR, such as patents, trademarks, and designs. Typically, need to carry out patent, trademark, and design searches on granted or registered IPR. Need for also looking at the patent applications published after 18 months of filing of patent applications.
How do I protect my inventions, trademark, and design in a foreign country?
It is good that you're thinking of taking timely action. In fact, you can apply for grant of patents, trademarks, and design in joint states and still maintain your priority for the Indian applications.
Priority? What does that mean?
Well, it means that if your patents, trademarks, and designs are granted in joint states, then your ownership of IPR in joint states will start from the dates of filing in India.
Well, what exactly needs to be done for protecting my invention in joint states through patents?
In order to obtain priority, we should file our applications within 12 months of filing in India. Here we have two options. First, we can file applications through Paris Convention in joint states and other countries which are members of the Paris Convention. Alternatively, we can file an application under the Patent Cooperation Treaty, PCT. However, if you don't wish to have the priority, you can file directly in the joint states. But remember, this should be done within 18 months from the date of filing your patent application in India.
18 months? Why?
This is because patent application gets published after 18 months and you lose the novelty.
In that case, what alternative should be picked by us?
I recommend you file PCT applications. Let me briefly explain to you a few things about PCT. PCT is an international treaty for claiming your domestic priority in member countries of PCT. In addition, you can file applications in countries of interest within 30 months of the priority date. Under the PCT system, a patent search report is provided, and on demand, a preliminary examination of your application is also done. This additional information helps you in delaying your investment by 30 months.
That's great. I can easily file PCT applications as 12 months have not elapsed since I filed my Indian applications.
You're on target. We should file applications without any further delay.
Please go ahead, Dinesh. Also tell me how to protect trademarks and designs in foreign countries.
As explained earlier, one can file trademark and design applications in member countries of the Paris Convention within 6 months of filing in India.
Paris Convention?
Paris Convention. Now, Paris Convention is an international convention that promotes trade among the member countries. It is devised to facilitate protection of industrial property simultaneously in the member countries without any loss in the priority date. Paris Convention applies to the protection of industrial property and includes trademarks for 6 months and industrial designs for 6 months.
Let's file applications for patent, trademark, and industrial design in joint states.
Hello Abhishek. Congratulations. All the applications have been filed.
I know I can bank upon you.